to our public access series, from Moody to Goose Rocks, public access and private ownership of the Maine shoreline. My name is Paul Best, and I'm the director of the reserve. Thank you for turning out on such a beautiful night. I think I mentioned at our last lecture series, it takes people who are really interested in beach policy and beach access and all the related issues to come out on such a, which is really just a fine beach day. We have a big tent outside, and if we didn't have PowerPoint this evening, we'd probably be reconvening and meeting under there, because it is absolutely beautiful. But we're going to keep the doors open so you get a nice breeze through here, and hopefully we'll be able to keep the mosquitoes at bay. This is the second of a three-part series that examines the issues surrounding coastal ownership and public access on Maine shoreline. This being the 25th anniversary of the Supreme Court decision called the Moody Beach case, it's hard to believe it's been a quarter of a century since then. And with the recent developments related to Goose Rocks Beach, as well as a series of other court decisions over the last 10 or 15 years, we thought it would be a really good opportunity to examine the issue, to go a little bit more in depth, to hear from some of the people who have been involved in it, who have argued some of the cases throughout the time. The goal of the lecture is simple. We want to raise people's awareness and understanding of this complex topic. We also want to give people an opportunity to hear different perspectives on it. Because there are different sides, there are different nuances, and there's different information other than what you may read in the media. These are complex, and it's always good to hear from people who kind of live it, if you will. And the third, perhaps most important, is perhaps we'll take some lessons away from this. I think we're all lifelong learners. We want to learn, we want to discover, and that's really one of the goals of the series. This evening we'll hear from Ben Leoni and Pete Thaxter, attorneys with the law firm of Curtis Thaxter, and from John Duff. If you may remember, if you were here a month or so ago, John Duff is our partner in this series. Our concluding event will be on October 2nd, Thursday, October 2nd. We haven't set the time yet. I'm going to do that tomorrow. I'm going to be working with the dean of the law school there. Sometimes it's going to be either 5 or 6. If the public's going to be welcome to it, we're going to want to have law students there as well. And we're going to develop an all-star legal cast in this event. We're going to have Ben and Pete will be there. Orlando DeLogue, Professor Orlando DeLogue, is Professor DeLogue here? I thought he was on the list. He's probably written and opined on this topic as much as anyone, so he'll be on the panel. Our own Derwin Parkinson. Derwin is from the town of Kennebunk. His law firm is here. He's been in the thick of this issue for at least 15 years or so. And we're trying to get a soon-to-be-named retired Supreme Court justice who has some background in this issue. And a couple others who will be involved in it. So stay tuned. Check out our website at www.wellsreserve.org. We'll have the information up on our website real soon. Of course, we've got a loaded summer. If anyone is a member of Laudholm Trust or comes here, we've had an incredibly busy, exciting year. So in addition to this series, we've been very busy in a project called the Sandy Dialogues, where it's kind of Nick calls it our foreign exchange program with New Jersey. We brought some decision makers down to New Jersey to learn about, what did they learn from the Superstorm Sandy, and what can we learn from it? And they're coming up here, representatives and decision makers in New Jersey, to meet with us and various community members. Chris Ford is here. If you want more information, she'll tell you about it. We also have the flyer on the table back there. But we have guided kayak trips. Last night we had an awesome pianist, just absolutely beautiful. Benny was there. We're going to have more music to come. We have a project going on with Purdue University. It's called Soundscape Ecology. This is a groundbreaking research project that's studying sound, the sounds of nature, and how much the human element can sometimes intrude on that. It's a little more complex than what I'm making it out to be. And of course our science projects, a lot of great research projects. As a matter of fact, 1 hour ago, out that window, out that door I should say, there were about 1,000 dead green crabs. I'm glad they're gone, if you are too. And we're conducting a research project to find out just how pervasive this invasive green crab is in our salt marshes, because we think it's doing some significant damage to certainly our soft shell plants, but also what we're looking at is the salt marsh peat. That's the foundation of our salt marshes. So that and many others. I would be remiss if I didn't say Laudholm Trust, our private nonprofit partner, funds us. If you're not a member, Nick Sheriff, the president of Laudholm Trust, is there. We're always looking for new members. It's a great organization that supports our activities. I would like to just briefly mention our other partners. I mentioned Nick Sheriff, president of Laudholm Trust, Maine Senior at College program, and the Maine Coastal program are also partners in this, as well as John Duff, who I will introduce in just a minute. There's a couple of things you have on you should have these. If you don't, let me know. A postcard that has information about our 3-volume set. It's called the Public Coastal Access Guide to Maine. You can get there from here. We've done tremendous progress over the last 20 years in acquiring land, acquiring easements, agreements, boat launch sites, bird watching sites. It really is quite astounding what we have along the coast of Maine. There's a heck of a lot more work to be done, and our reserve is involved in that. But we have those for sale. Nick has those for sale if you're interested. It's just produced with the Maine Coastal Program and the Mountain Reserve. The second item you should have, if you don't, we have copies at the table. In fact, is a evaluation. We are interested in your thoughts. We handed this out at the last lecture series. We got great input. We incorporate that in. So if you please fill this out at the very end, we would appreciate it. Just keep it on the table, and there are plenty of pens back there for you. So finally, before I turn it over, I would like to say that there's going to be some tangible outcomes from this series. In addition to the great discussion and ideas and thoughts that will come out of this, we're going to reproduce, revise, completely new Citizens Guide to Ocean and Coastal Law. We are going to take everything that you're going to hear tonight and much, much more, and it will be in this new publication. And we have some copies on the back table if you're interested. Keep in mind that it is a decade old, and by next year at this time, before that, we'll have a new one out. And we'll also be revising a website called Accessing the Maine Coast, produced by Maine Sea Grant 6 years ago. We're going to be totally updating that. That is a one-stop shop for your knowledge and information about shoreline ownership, and shoreline access. So with that, I'm going to introduce our speakers. I'm just missing a minute. We'll go with John Duff. John Duff, as I mentioned, is our partner in this series. He's an associate professor of environmental law and policy at UMass Boston School for the Environment. John received his law degree from Suffolk University Law School in Boston and his master's in environmental law from the University of Washington. Over the last 25 years, he has worked as a newspaper reporter, an attorney in private practice, and served as general counsel to a nonprofit organization focusing on marine habitat protection issues. He has directed the marine law research programs at the law schools of the universities of Mississippi and Maine, and that's where I met John probably 15 years or so ago. He's a co-author of the book International Ocean Law and serves on the editorial board of Ocean Development International Law. And as I mentioned earlier, John is the author of the Public Shoreline Access Guide in Maine, a Citizen's Guide to Ocean and Coastal Law, which we are revising. Next up is Pete Thaxter. That's Sidney Pete Thaxter. Oh, thank you. She pulled that right off the website. I got it now. Oh, isn't that great? Boy, with technology. See, I'm relying on the paper world here, and I have people with technology. I've got to catch up. But I found my piece of paper. So Sidney Pete Thaxter, I'm really delighted to meet Pete. I first heard about Pete and his law firm probably about 30 years ago when I was living on Muncho Hill. And then I was reintroduced to him when I moved back to Maine in 1989, because that was when the Moody Beach decision came down from the law court. And he's been well known ever since by not just folks who lived up in Portland. He's one of the founders of Curtis Thaxter Law Firm. For more than 30 years, he has successfully represented oceanfront property owners in protecting their property against claims by towns, the state, neighbors, and the public. His most notable representation in this area of law has been 2 landmark cases involving Maine's beachfront property rights. That's Bell versus the town of Wells, the quote-unquote the Moody Beach case, and the Almeida et al. Versus the town of Kennebunkport et al. which is we refer to as the Goose Rocks Beach case. In 2005, Pete published in the Maine Law Review an article called Will Bell versus the Town of Wells Be Eroded Over Time, or with time, and we have a couple of copies. For those of you interested in this topic, there's more information on the table back there. That journal article is published there. And that article details the history of the colonial ordinance of 1647, which governs all in our title zone. Pete's law degree is from Boston College Law School with his BA, and he had received his BA from Middlebury College. Pete is very active in his hometown. He served on many boards, but one that's of interest to me here and us here, he was involved with the Portland Historic Preservation Commission. And he's probably seen this by looking around our nationally registered campus. This is historic preservation heaven here, or anything but if you got to try to find money to pay for it all. Okay, on to Ben Leoni. I got to know Ben last year. Ben agreed to serve on this, I think, a really good panel discussion at the Maine Beaches Conference in July of last year. Ben is an attorney with Curtis Thaxter in Portland who represents beachfront owners at Goose Rocks Beach. His legal interests include property rights, takings, and environmental law, as well as environmental dispute resolution. He serves on the boards of several conservation organizations, including the Northern Forest Center, and he is a former Institute for Civic Leadership trustee fellow at the Maine chapter of the Nature Conservancy. In 2011, Ben won a National Burton Award in legal writing for a legal article he authored on engaging stakeholders in resolving land use disputes. He received this award, which I think is cool, at the Library of Congress from Supreme Court Justice Sonia Sotomayor. Ben holds a law degree from Vermont Law School and a BA from Bates College. And when I found out about Ben this past winter, I was reading the Bangor Daily News. It was a front page story. He is an adventure alpine skier, goes to places no other skiers will go, the steepest, most remote places. And I think he even videotapes it too, or records it. So anyway, he's a daredevil, in addition to being a very good attorney. So with this, I'm going to turn it over to John Dow, our partner.
Thanks. Thank you for all coming out again tonight. I love coming back to Maine, and I'm happy that you folks are all coming back to these presentations. I'm going to keep this relatively brief. For those folks, can I get a sense of how many folks were here for the first of these sessions about a month or so ago? So a fair number do, maybe half, maybe a little bit more. I mentioned at that time that understanding some of these issues requires not just an understanding of the law, but as importantly, an understanding of history. So I'm very happy that Pete Thaxter is going to focus on the history of Moody Beach, which in and of itself requires kind of a recitation and a summary and a review of 4 centuries of law that apply to that situation. Now, last time, in a bit of bravado, I suggested I was going to run through 1,500 years of history in 8 minutes. We're going to let Pete take a much more leisurely pace to go through 4 centuries, and he can have the better part of 20 minutes to get through 4 centuries, I think. So we'll be hearing about that. Then we'll turn it over to Ben. And Ben is going to talk about 3 different types of disputes, each of which stems on where you are along the coast. That is, if you're in the intertidal zone, or you're in the dry sand area, or you're trying to gain lateral access to the shore. Because where you are sets the stage for what the laws are and what the interests are of the private property owners and the public in general. And lastly, I want to give credit to a number of folks who wrote the very first edition of the Public Access Guide to Maine, which actually came out prior to 2004. My work in 2004 came about in terms of revising it, and in fact it's due for a revision again because of the dynamism that has taken place in the last 10 years with a series of cases that really highlights some more detail and some more nuance of the balance of interest between private and public interest. So with that, I'm going to turn it over to Pete, and he's going to help us go through the history of the Moody Beach case. Thanks.
Thank you all, and thank you for the introductions. My name is Pete Thaxter, and I must say that I'm feel very privileged to have had these 2 cases that are kind of landmark cases and to have started when I did back in Moody Beach, and I was obviously a very young man back then. And that started, my personal history with Moody Beach started in in 1983. So they've got a long history. And also, I have written an article that's in the Maine Law Review. There's some copies back there that goes in depth. I could talk forever on any part of this stuff. And so what I'm trying to do, and what they asked me to do, is kind of give an overview with sort of the general history of this thing. So I'm not going into the legal arguments in any detail. I'm just trying to, as best I can, give you what happened when and what's the history been and how does this all develop. And of course, we have to talk about the law as part of it because it is part of it. And there also was a good article in Down East Magazine, a guy named Rob Snedden, in the July 2014 did an article. And he did what I've not seen any of the other folks do, is he did an in-depth article. He really read all the stuff. He did the research. We talked to a lot of reporters, and one of the questions we first asked him is, did you read the decision? And most of them don't even read the decision in question. So back in the Moody Beach days, I spent a lot of time trying to educate them, and then I finally gave up because most of them have deadlines that are too short to get into it. So there's a great deal of misinformation out there, and for those of you who may have been misinformed, I hope that this can help sort of set the record straight. So I just want to talk a little bit first about the Maine coastline. We've got a lot of coast, and most of it's privately owned, but of the beaches, 50% of the beaches are really publicly owned. And if you look at most of them, you go to Popham, you go to Old Orchard, you look at most of them, the beaches that are not publicly owned are very small. I think most of them have been addressed by now. So most of the problem comes with these big sandy beaches, but there have been, and we'll talk about some of the problems that have come up with the smaller beaches and access to the smaller beaches. In 1983, my partner Kermit Lopez and I were approached by two gentlemen from Moody Beach, Dr. Warren Jones and Bob Kirk. And they came to us in 1983 telling about the problems and travails they had that were going on down in Moody Beach and asked us if we would represent them. Kermit went on to be a judge in the next year, so I ended up becoming the lead counsel in the case. And so what happened to get the Moody Beach case going back then? Well, Wells and Agunquit split apart before that time, and the beach itself, Agunquit Beach, went with the town of Agunquit. And whether Snedden thinks that had something to do with it, I don't know if it did or not. But there was a lot of commercial pressure to have beach access. All of those campgrounds on the other side of the one were advertising on Moody Beach, and they were shipping people down in buses. And what the town had done, it had taken 3 rights-of-ways, 20 feet wide, running right to the Atlantic Ocean, and taken those by eminent domain, and put up lifeguard stands. There were no bathrooms, there was no beach cleaning, there was nothing to support the rest of the beach. So all of these people were getting shipped down, and it wasn't too long that it just got to be a problem. Most of the people didn't care. These are very nice people, and as the judge who heard the case found, there were not these rich demons from away. Many of them had been there for years. In fact, one of the witnesses said he believes he was conceived on the beach. So these families had been there for years and years, and they had a nice community. And they initially were only asking that for some help from the town. They wanted the town to help them with this problem of people being abusive, people leaving their stuff there, not having bathrooms. This is a picture of Moody Beach. So Moody Beach, the houses are a little more dense than they are in Goose Rocks. You've got 100 privately owned lots with these 3 rights of way the town can take. And there's no question the title of the beach, because Mr. Tibbetts, the prior owner, had actually got the deed from the state of Maine. So it's clear that everybody's deed ran to the lower. So you have this, and it's also there for those of you who know it, that there's a large title zone when the tide goes out, but when it comes in, you're up against the seawall. there's always in legal cases lots of issues that don't really count for much, but the two that really counted were a claim for a prescriptive easement and a claim that the colonial ordinance from high water to low water, the public had a right to use. Those were the two key claims. In that case, and there were the two key claims in the Goose Rocks case. A prescriptive easement is, and Ben's going to go into it in more detail, but it's like adverse possession, somebody saying, I have a right to use your property because I've used it. But it's very difficult to prove, and there is something that Ben will talk about called a presumption of permission. The landowners in Maine, we have a long tradition of letting people use their land, so we were joined in the Goose Rocks case by the Snowmobile Association and the Northern Lands people, because if you're generous and let somebody use your land, you shouldn't have to fear it's going to be taken. And so that presumption of permission legal standard was in place during the Moody Beach case as well as the Goose Rocks. So this is a comment from Rob Snedden when he talked to Jonathan Carter. Jonathan wasn't the town manager at the time of the lawsuit, but he admits that it was a mistake, that if they talked to these owners, if they really considered their rights and looked at their legal situation, they may have gotten a lot further, because these people weren't trying to exclude everybody. By and large, when you get 100 lots, there's always somebody that, doesn't want people in their property, but most of us, I always told the backlot owners there who were complaining too, I said, if you're a backlot owner, you can't find a friend in front, you're not a very nice person. I mean, you ought to be able to, out of 100 homes, you probably got some friend who's gonna let you use the beach, And they were part of the community, and that's what happened. In most cases, they walk right through their friend's property to get to the beach. So I think Sned's comment is important because it just goes to show that you've got to talk first and act later. So anyhow, the case got going. We brought the case, and there were the two issues that I mentioned were there. But colonial ordinance became the key issue. I've got a whole section in my law review article on the colonial ordinance, and I can go on forever, but it comes from an enactment called the Body of Liberties. The Body of Liberties was a culmination of an agitation by members of the colonies starting in 1634. And it was more than just this colonial ordinance. It was a whole body of different laws to protect themselves. They had a weak king. They were trying to take advantage of a weak king and enact some laws that, in fact, kind of declare their independence. Some call it a Bill of Rights, some people, some call it a Magna Carta. We had a legal historian from Penn, George Haskins, who writes a wonderful book about colonial legal history working with us. He knew, everything about this. He knew who had signed this document, who had done what, when, and where. So he was a great help for us in this. And so the colonial ordinance, what happened was that it got adopted, and what it said was this. It said the upland owner of shorefront property owns to the low water mark or 100 rods, whichever's closest. So 100 rods is 1,650 feet. So what the ordinance was trying to do was protect these colonists from the king coming in and claiming title. And so this was the title of Maine and part of Massachusetts back then. So this was the law. So if I own the upland, I own to low water. The public was given certain rights. And back then, these were important rights to the people. They could hunt, they could fish on the beach, or they could navigate, or they could, park their boat to get up to the upland and to go someplace else. Remember, this only involves the intertidal zone, and as Ben will point out to you later, most of these disputes are not just about the intertidal zone. Moody Beach was not just about the intertidal zone, it was about the upland too, because the towns and the public won't control the entire beach, because what happens when the tide comes in, it's just going to turn into a mess. So most of these cases are not just about the intertidal zone. That case started, and the judge initially found, the state argued that, oh, no, you can't bring this case because the intertidal zone is imbued with this doctrine called the public trust. And because of that, the sovereign is in control, the sovereign being the state, and we can't sue the sovereign. And the judge initially agreed with them. What is the public trust? Well, across the United States, there are lots of states where from high water to low water is owned by the state, the public. In Maine, the submerged lands are owned by the public and subject to the public trust. That means the state is the trustee for us, the people of that land, that submerged land, but not the intertidal zone of Maine. So Maine and Massachusetts are different, and they've always been different. And the Supreme Court, the U.S. Supreme Court has recognized that over time. So the bell, so what happens when the judge did that, we appeal. So this is in that decision gets made in 1986. Justice Glassman was on the court, she was the first woman on the court, and we got a unanimous decision that the colonial ordinance was not part, that the intertidal zone was not part of the public trust, and that the colonial ordinance was an easement in the public, and then if there were any trustee of it, the trustee would be the owners of the land and not the state of Maine. So we were permitted to proceed with that case. Remember, that was a unanimous decision. People often hear about the second case, which was 1989, which had a lot more notoriety, but this unanimous decision was the one on which all of this is based. The second decision was more about the scope, what did fishing, fouling, and navigation mean? Now, there are a couple things that people ask us about. Some people will say, well, why didn't the state take this? Why isn't the state in control? And the state could be in control, or in the towns, but they have to take the property by eminent domain and pay money. So in none of these cases did they want to pay the money. During the Moody Beach case, the legislature passed the Intertidal Lands Act, and they declared that the public owned the intertidal zone. And in the second Moody Beach decision, the court found that it was unconstitutional. In other words, that this was private land. You can't just come and declare somebody's backyard is now public land. You just, this is these people's property. So that was held unconstitutional in the Moody Beach 2 case. So what happened in that case was that we then tried the case before Justice Bill Broderick in the lower court. It was actually tried in a historic courthouse up in Wisconsin because there was no room down here to have a trial with that many people watching. And after a while, there weren't very many people because these things aren't that exciting, to be honest with you. There were 70 witnesses that came up, and the judge heard these people who lived there for years and heard their concerns and heard what was going on. And he found, the lower court found in the Moody Beach case that there were no restrictive rights, that somebody testifying they were on one property one day, not half a mile down the beach the next day, you can't take somebody's property in front of their house without that person being on notice. He found there was no evidence of it. Plus, they had not overcome the presumption of permission. They hadn't showed whatever use was being allowed was not permissive. So he found for us on that issue, and he also found that the colonial ordinance was limited to fishing, fouling, and navigation. So the town and the state of Maine appealed that, and that was the second Moody Beach case. And that case got a lot of notoriety because it was a split decision. It was a 4-3 decision. Chief Justice McCusick wrote the decision. He was a brilliant guy, clerk for Felix Frankfurter, and he wrote for the 4. And these were all new justices except for one from the 7. And the one, Justice Watson, wrote a dissent. And I addressed this in my law review article. The problem with his dissent is he never explains how he gets from the first case to his opinion in saying in the second case that fishing, fouling means really recreation. So the issue that the state raised, and was raised in the second case, was that what is fishing, fouling, and navigation meant in the following words? You know, the state was arguing, well, those weren't words of limitation, it just meant for recreation, because that was what was being done back when the colonial ordinance was passed. But Justice Broderick had found this a matter of historical evidence. The Pilgrims back in 1647 did not go to the beach. This was not. We actually had a witness testify, an expert. They didn't like to get cans. You know, there were articles by the Pilgrims saying, "Don't worry, if you get inside, it'll go away." You know, but what happened though in the second Bell case was the court said all this history doesn't make any difference. The colonial orders became part of Maine law in 1820 when Maine became a state, and there's a whole series of Massachusetts cases that have interpreted fishing, fouling, and navigation and what it means. It doesn't mean walking, it doesn't mean having picnics. They've interpreted very narrowly over those years. The Maine courts since 1820 have interpreted it also in the same narrow way. There is no case, in my view, that says that there are any rights broader than those rights, but you get to the McGarvey case, which is a recent case, and you see the court saying, well, is scuba diving navigation? They do apply a liberal interpretation of those, but still they're using those three terms. So that's been the history of the colonial ordinance, pardon me, up till the Moody Beach case. And then the second case, the 43 decision, reaffirmed that fishing, fouling, and navigation. And Justice McCusick talks about the fact that never has a decision been made except in dealing with those three terms. So, you know, everything was predicted to go to hell in a handbag after that. And it really was very quiet. We didn't tell the Goose Rocks case. I know the Eden case happened in 2000. There was one case in Wells. But until the Goose Rocks case, there hasn't been that much litigation about this. I think the law is clear, and I think a lot of lawyers understood that, and we have a lot of cases going on. So why did Goose Rocks happen, at least in my opinion? Well, Goose Rocks has been a very quiet, wonderful beach. And until 2000 or after 2000, then we'll show you a picture where, you know, there were very few people even present on the beach. And the owners were generous and let people use that. The town comprehensive plan, starting in 1995, said this is a private beach. And these owners are nice and they allow people to use it. And there were even things in there saying you need to respect their rights. That Goose Rocks, many of you know, has a center part of the beach where there were 9 lots that were owned by the Conservation Corporation and 1 by the town. And that was what's called a public beach. That's where the lifeguard stand was. That's where, you know, the majority of people went. But there was no pressure on the rest of the beach until sometime after 2000. And just the same pattern came about. And we, having gone through the Moody Beach case, I spent a great amount of time making the clients tell me the story, looking at all the facts, making sure we're straight before we got into the case. And the evidence was, oh, you have Goose Rocks Beach is 2 miles of sandy beach. And you have some of these lots that were, you know, some of these people said, I never saw anybody in front of my house. And yet some of these people who had a lot of people in front of their house, because they near the access ways. You can see way up there, there's very little built up behind the beach, but down to your right, what you can't see is the build-up more development right behind the beach. And that's where the public beach is. So that for somebody way down at either end, like Bob Elliott way down one end, you know, he had his friends there and a few other people, hardly ever saw anybody. The testimony in the trial was that, well, we walked the whole beach from up and down, but nobody ever showed that they were in front of any particular lot. And it was a real no-brainer for the law court to say, the lower court did not deal with this presumption of permission, and he never found that this use was adverse, because it wasn't adverse. There was never a finding of adversity which you need for prescriptive use. So the Moody Beach case was really more about the colonial ordinance. The Goose Rocks Beach is more about the prescriptive easement and how, what the standards are. And the court basically overruled the lower court saying, hey, you didn't have any evidence to prove these things. Now, granted, it's being reconsidered, but the reconsideration request and the reconsideration is focusing, in our view, entirely on the issue of the colonial ordinance. And it's the same debate that went on in a recent case, in the Garvey case involving scuba diving. There's 3 judges who say, well, you use the word public trust, and there's 3 who say, no, there's no public trust. This is an easement, and you got to be clear about that. The 3 who are saying there's a public trust, well, this is the camel's nose under the tent. You know, they're saying, well, yeah, but you can't do anything but, you know, really like fishing following the navigation. It has to be related to going to the water. You can't sit down on it. You can't recreate in. So they're sort of saying we're going to be tough on it, but we get to interpret it a different way than it's been interpreted for the last 400 years. So that's where it is today. You know, when the town, what happened in Goose Rocks Beach is in 2005, and one of our clients was a former selectman, so we knew what had been going on. They had been treating the beach, according to their comprehensive plan, as a private beach. The police would come down, they would move people. A very nice police chief. He didn't want to be testified for us at the trial because he was instructed, this is private, but don't cause a fuss. Don't, you know, arrest people. Just ask them to move on to leave. There were a few people on the beach who, you know, we didn't like what was going on in front of the house and we called the police periodically. So there were lots of police reports, and he talked about how he handled it. In 2005, without announcing it to the town, they changed the policy and said you will no longer, you know, tell people to move on. You will no longer enforce private property rights. And we have a letter from the town's attorney to the town saying this is the way you go to develop a prescriptive easement. So it was clear to these people that the town was working on a prescriptive easement case going forward, so they had little choice. They were going to lose their control of the land, or they had to bring a lawsuit, which they did. Our position would be that if you accept these owners' ownership rights and not demonize them to start with and talk to them, there may have been some way to get down to have the discussion, because it was very disturbing to a lot of people on both sides. And nobody wanted to have it. And, you know, hopefully the community will feel sometimes. Some folks aren't talking to each other, and it's very difficult. So the appeal is still pending, but look, it's not really an appeal because it's a reconsideration, and the court really is limited in what it can reconsider, and it's pretty much indicated what it is reconsidering. So thank you all very much. And if you have any questions now, I'll take them, and Ben will take some after his, and then, you know, if you want me to ask questions, answer questions after Ben's talk, I'll be happy to.
So I hope you'll join me in thanking me for this part of it. Ask a couple of things. When you ask a question, I'm going to ask Pete to summarize it and restate it so that everybody can hear it, and then you can respond to it. And then I think we may have some index cards available that we might be able to distribute. So if you have thought of something, or if you continue to think about something, and you have a question, jot it down, and at the very end of the evening, we'll look at those and see if we can synthesize some of those into some common questions. And at the very least, we can take them with us and incorporate that into the revised petition. So with that, any questions on this?
I just wonder if he could use the mic up for me.
Okay.
Turn the mic up a little bit more.
Can I
switch?
Turn that one, I just turned on. Is that better?
Another switch on there.
There's another switch on it.
Is that better? Yeah. Okay. Sorry. Yes.
Just go back to the picture of Goose Rocks and point out approximately where the public and the private points were. Yeah.
Yeah, this is, if I'm correct, and Bob Sherman's here, you can correct me, there are some people here. I think this is what's called Dinghy Point right here.
Yeah.
And the public section's down here. And more in the middle, and way out there is the other end. Where Laudholm is.
And let me just suggest that the Portland Press Herald, when it did the coverage, had a couple of visuals and graphics, and I think one of them was a map with delineations. So we will be posting that on the Maine Sea Grant site. But if you're anxious to see it, I think if you just go into Portland Press Herald and look at Goose Rocks, you'll come up with some of the visuals, including the map of the area.
You did mention 2005, the town changed their policy. And you may have mentioned why. Could you tell me why the town changed its policy of not gently asking people to leave or not doing anything?
Yeah, we don't know for sure exactly why. What happened was that we found a letter from the town's attorney to the town manager, which said, if you want, it says the beach is private. It says, you know, the public has the right to fish and foul in the intertidal zone, but if you want to develop a claim for prescriptive easement, you have to stop enforcing private property rights. And we think that was the genesis of it. I don't, you know, it was, they don't take those kind of minutes to the meetings when they're doing those steps.
I just had a question about the prescriptive easement. I always thought that it had to be compensated first, so that if they're not compensated, the land is yours.
The question was for a prescriptive easement, if you're not compensated, the land is yours. And
I mean, if your deed said you own that.
yeah. The answer is, if it's eminent domain, they have to compensate you. If it's prescriptive easement, technically the argument is that you or the public have used this in a way so long that they dispossess the owner of their rights, and therefore they don't have to pay them. So that's why this presumption of permission exists, so that the owners can feel more comfortable.
Even though I've been a homeowner now for over 30 years, and I really do love the product, and I'm not from Goose Rocks, I'm from Wells. I really get very upset when I put my chairs out and when high tide comes. They put their chairs directly in front of mine within 2 or 3 feet. I own 54 feet of oceanfront, and I kind of clean it myself because, to be quite honest with you, I don't think the town of Wells does a good job in cleaning the city. And in fact, they only been twice this year. And I therefore find that they go to that area, my 12 feet, and that's right where they go. And I love the people, and I have never asked people to leave. I have asked them to move, but the seaweed is there, and they don't want to do it.
This is the person asking basically how you deal with some of the problems when people are impinging on your own personal space. And I mean, people have developed back in Moody Beach. I mean, beside the rights of way, there are some of them put their kayaks and put their sailboats. And on Goose Rocks, some people put out their chairs and try to do different things to keep a circle around at least the protected area. So, especially if it's their own property, they just want to be able to use that. Ben's going to talk about one property where it was so remarkable from, you know, the picture in 95 when there are 2 people around, and then the woman wakes up one morning and somebody's got one of these beach tents, and it's right in her picture window. I mean, you can't see the beach, you're just looking at the beach tent. So, you know, I think it helps if the town tries to educate the people and have some respect for the people who live there.
Well, every time I ask people to move, they just immediately look at me and say, you don't own the land, this is a public beach. And I say, well, I think you should go with you. And I feel the town makes no effort to let people know that not all from Wells Beach is public.
And these are the questions we have had, the problems of notification and the public's response, and yeah, it's a continual problem. Yes.
Is there an accepted time period for prescriptive right?
Yes. The question is there an accepted time period? I should have told you. It's the same as for adverse, 20 years. But you have to show that for those 20 years, not only was it used, but it was used in a manner that you should, as the owner, would have to know you're going to lose your rights. And it was used in a manner that disregarded your rights. And if you break that once in 20 years, if you come say, get off of my property, or you say, here's a permission slip, then you start another 20 years. I mean,
Well, you don't have to say it for 20 years. That just restarts it.
Right. Right. That's a,
Was it a part of the Eaton case in Wells?
well, the Eaton case, this is a question about the Eaton case in Wells, which the court did find a prescriptive easement. The Eaton case was very different because Mr. Eaton was the fellow who developed the whole area. There was 300 backlots, and I had a friend from college who came back and told me his parents had bought one way back in the 50s. But what Mr. Eaton did is he made this development, and if you owned the house on the seawall right on the beach, you didn't have a deed to your deed just ran to the seawall, so you didn't actually own in front of it, and he kept that property. Under today's modern law, that would be common property of the development. I mean, it was pretty clear in the development. I think the case was decided wrong, and the judge should have said, you know, these people have the right to use the beach because it's shown on the plans, and it's shown as almost common land. It was just poor lawyering back then, and somebody forgot it, and he forgot it until the town took the rights of way like they did in Moody Beach back in the 80s, but they still did nothing, and it was, the town had just taken total control of that. Ben will talk about that someday.
And given that Ben's going to talk about three different types of conflict, I'm going to suggest for the sake of time, if you think, if you've got a question that's very particular to the presentation that's just been given, and you have a brief question, that'd be great. Otherwise, I'd like to give Ben an opportunity, and then maybe reconvene for questions at the very end for either one of you.
Yeah, and I can stand up at the end, so, yeah, because Ben's going to answer some of the questions
Yeah.
I think you have out there. Thank you.
Can you wait?
Pretty loud, so hopefully you can all hear me, and if people are having trouble, just do this and I'll see you. So I'm going to talk about in four different areas. I'm going to talk about what kind of beach use disputes exist out there in Maine, and why does it matter that we label them differently. Then I'm going to talk a little bit about the landowner's perspective in some of the cases that our office has dealt with. Then I'm going to talk a little bit about prescriptive easements and what those are all about. And I'm going to talk a little bit more about the Eaton v. Town of Wells case and the facts in that case, and then at least my perspective on the facts in Goose Rocks Beach case and why the Maine Supreme Court found for the town in Eaton v. Town of Wells, and my perspective on why the Maine Supreme Court found for the landowners in the Goose Rocks Beach case. Same exact claim of prescriptive easement over a piece of beach. And then finally, I'm going to talk about, isn't there a way to avoid these costly lawsuits? And the answer is yes. And so I hope to end the talk tonight with maybe some good news, and we'll move on from that. So I'm going to start with talking about the three types of beach use disputes. And the first kind is, I just call it perpendicular access, which is you don't get a beach dispute, you don't have an issue over the use of the beach unless you can get to the beach. And in the last 4 years, these are just cases I know personally about. There may be more. These are 4 cases that have happened in the state of Maine that all deal with perpendicular access. It's usually the public's right to use a road that leads to a beach that's a private deeded road. Or maybe if you live on a beach, you're familiar with the fact that many people have a small private easement or right-of-way that goes over the beachfront property for people that live behind. Well, what happens when the public says, we don't want that to be private and just for 5 people, we want everyone to be able to use that right-of-way. So those are perpendicular access disputes. And those are for Flaherty v. Muther. It had to do over the scope of that right-of-way, who was allowed to use that right-of-way. Bayberry Cove v. Town of Steuben was a case involving a prescriptive easement. The landowners prevailed in that one, the town lost. There's a recent Owl Head dispute, which some of you may have seen in the Press Herald. There was an article just 2 days ago about. That's an ongoing lawsuit that just is getting appealed to the Maine Supreme Court. And that concerns whether the public has a right to use a driveway that leads to a beach, whether they're allowed to walk down the same driveway that people park their cars on a single lot and get down to the beach that way. And then Friends of Cedar Beach versus the Abramsons. That's a case actually our office is involved in Harpswell. You may have heard it referred to as the Cedar Beach case. And this picture here is a picture of Cedar Beach Road, which is a deeded private road down to the beach, and that's at Cedar Beach. This was the sign that got put up that resulted in the lawsuit. And then there's two kinds of what I'll call beach use disputes. There's disputes that concern just the intertidal land, and that's what you had in the Garvey v. Wittridge, a case which pitted loaners of intertidal land against a company that was doing scuba diving. They gave scuba diving lessons, and people were walking over this private property, landowner's property, to get to the water to scuba dive. And so the question in that case was, is that allowed under fishing, fouling, navigation? That's the only case I could find in the last 30 years that just dealt with the intertidal zone. Because as Pete alluded to, if you're on the beach, what happens when the tide comes up, you still need a place to go, which is why most of the big beach disputes that we've talked about, Moody Beach, Eden Beach Town of Wells in 2000, and Goose Rocks now concern both the intertidal zone and the high dry sand. So why is that important? Well, we hear a lot about the colonial ordinance and the rights in the intertidal zone, and one thing that continues to happen in the litigation before the Supreme Court in arguments is that people that argue for an expansion of public rights in the intertidal zone say, look at all of these lawsuits that come because you haven't expanded everyone's right to access. So now you got people asking if there's scuba diving, you've got people asking if there's surfing allowed. Why don't you just give us a blanket statement that says recreation is allowed under the public trust doctrine? It'll solve all of our problems. And I think that really misses the mark because most of the cases don't primarily concern just the intertidal zone. And expanding the rights in the intertidal zone will do nothing to resolve the disputes that happen over the high dry sand, which is usually, if you live on a beach or know people that live on the beach, that's the portion of the beach that they are the most sensitive about. I have some clients currently who are engaged in a dispute with a neighboring commercial property, and they own down to the low water mark, but they don't care about people using the intertidal zone. They only care about how people are using their high dry sand. So that's why it matters. So why would a landowner at some point try to resist public access? These are just some photos of some reasons from my personal experience dealing with some clients. You have cases, the case I just alluded to about the high dry sand. The public likes to trample on the grass, and they've lost about 50 feet of their dune grass because people have been walking all over it in the last 6 years. They also had people start a small fire in their beach grass because they wanted to have a fire at high tide and it lit some beach grass on fire. And then you just have littering, dogs, you know, doing their business, doing what dogs do, and people don't pick up after them. Here I have a picture of a plover as well. There's one property owner at Goose Rocks and many that are very protective of the plovers that are there. It's an endangered species. We had one who was very protective of the plovers nesting on her property. If you came by her property with a dog on a leash, she was going to come down and tell you to get off. So I want to talk about the causes a little bit with a bit of a story, not at Goose Rocks, but this is Cedar Beach, and or at least a portion of Cedar Beach. And I want to, just a show of hands, who's heard of this dispute? Any of you read about this? Wow, just great. It's been in the Press Herald, in the Forecaster a bit. But what happened was in the 1990s, a family named the Abramsons, and Charlie and Sally Abramson, purchased a property at the end of a peninsula in Cedar Beach. It's in Harpswell on Bailey's Island. If you've been to Bailey's Island, the bridge is just to the right of this photo. To the right of the photo. As you come across the bridge this way on the Bailey's Island. So you can see the bridge right there, and so they purchased the property. The property wasn't just beach property. It was upland. You can see the corner of the Abramson's house just on the left getting cut off, and that's their lawn right there. And this is the beach that they own. But they also bought the road. It's a Cedar Beach road. It's a private road, and there are 5 people or 6 people, I think, that have a deeded right over that road that the Abramsons own. The Abramsons, since the 90s, have let people come down and use both their beach, use the road, use their beach, and there's also a larger section of Cedar Beach that the Abramsons don't own, sort of behind the person that took this photo. And so people would come down the road and access the beaches. The Abramsons didn't have a problem with it. Charlie Abramson actually used to park his tractor at the end of the road before the path that comes down to this beach and sell ice cream to all the neighborhood kids that came down. He's a remarkably nice person, but in a few years ago he found that some of the uses of his property started to change. People were leaving a lot of trash on his beach, and more importantly, trash up on his lawn. He was picking up diapers, he was picking up dog poop, he was picking up trash, and by and large, most of the people that use this property are good stewards. But if you've got 20 people coming down using the property per day, and you've got just 1% of the population that's going to misuse it, that does build up over time. And he was finding diapers in the bushes, and he actually was hanging in a hammock on some trees that are sort of in the top of the picture up there, and had a guy come up and urinate on the tree 15 feet away from him. And the guy basically said, well, what do you want me to do? There's no public bathrooms down here. And, you know, I'm not making this stuff up. It happens. And this is the testimony, and these are some of the stories. And we don't like, it's difficult to talk about, you know, because we're talking about the bad actors, the 1% who misuse the property. But at some point, it gets to the point where in Charlie Abramson's experience that people begin to say, well, who are you to tell us what we can do here? And so what Charlie did to start is he didn't block off the road, but he just blocked off the little path that comes down to his beach. And he did that a few years ago. He put a little barrier across between 2 trees where the path comes down. And that barrier got torn out within a couple days. He thinks someone came down with a pickup truck and tore it off. But then he also started to receive hate mail. And he received a substantial amount of hate mail that was anti-Semitic. I read a lot of it. It's really disturbing. Threats to his family and his property. And he had a person to his face threaten to burn down his house and enact injustice. So Charlie felt like, well, this isn't enough. I'm not doing enough. He was worried about his family. And so at that point, he chose to block off access down the road. And once he did that, he put that sign up that said, private road, no public access, which blocked people's access both to the small beach that Charlie owned, but also to the bigger beach next door. A group formed of area residents, and they sued the Abramsons, claiming that there's a public prescriptive easement down the road. And interestingly enough, they actually didn't include a claim to the beach. They left it alone. They said, okay, well, you can have your little beach, but we still want access down the road to reach the big beach. So that case was only about the big beach or really about the road. I will say that the parties did try to engage in some conflict resolution. They tried to come up with a solution. Charlie actually had plans on maybe giving the road to the town, but there are a number of complicating factors I won't get into now. But there was a lot of effort on both sides, even the Friends of Cedar Beach group, with Charlie to try to work out a solution. It just simply didn't work in this case. So I use that simply as an example. That's a perpendicular access case, and those are the kinds of disputes that sometimes lead to these lawsuits. Sheer numbers. This is a picture of Goose Rocks Beach. This is the Dyke Road entrance onto Goose Rocks Beach. One of our clients lives in the house sort of in the middle, just to the left of the public access point. And this photo was taken in August. This was an exhibit at trial in August at noon in 1994. And just a few people there. This is what the client called the light day at Goose Rocks Beach now. This is taken from partway down her property, but you can see a high tide. There's a lot of people there. They come up onto the rocks. They put their stuff up there. And she now, at times, she says it's not uncommon to have 50 to 70 people in front of her property alone. And so she takes out some chairs and she kind of puts them in a semicircle to preserve some room for herself. And then finally, some of these cases start because you get an adverse claim of right, which is sort of the letter that Pete alluded to about the change in policy. If you have a town or the public that says, we view this as public property now, not private property, we're not going to recognize this as private property, it starts the clock on a prescriptive easement, and landowners really have very few options but to go to court and start what's called a quiet title action to show that the public does not have one. If they wait 20 years, as Pete alluded to, they lose their property. Quickly, prescriptive easements. I'm not going to get into it a whole lot, but this is the legalese. These are the 4 elements that come into place. The third is the most important. When the public is using your property for recreation, you need to show the court that it's adverse. And that's the court's way of saying the owner needs to be on notice that if they don't do anything for 20 years, they're going to lose their property forever. And so this idea of a prescriptive easement came out of the old, what are called the courts of equity, which is back in the English courts, you had courts that basically sat there and they tried to make determinations of fairness. And this claim of a prescriptive easement is all about fairness. When is it fair to take property, deeded property away from a true owner and give it to somebody else for free? And that's why it's very difficult for people that are claiming prescriptive easements, adverse possession to prevail, because courts don't like to take people's property away and give it to somebody else for free. So in Maine, we have this thing called the presumption of permission. You can't prevail in a prescriptive easement claim over private property if it's permissive. If you invite other people to use your property, they can't come back later and say, well, I've been using it for 20 years, now I have a right to use it, thank you, this is mine. So we have this presumption of permission in Maine, which is part of our tradition, and it has a double benefit. The first benefit is it protects landowners from lawsuits and encourages them to allow people to use their private land without feeling like they're going to lose their property for doing so. The second benefit, and this is highlighted in the court's decision in Goose Rocks Beach, is that if you are a public user and you want to use private property for recreation, the Maine law presumes that you have the permission of the landowner to use it for recreation unless the landowner comes out and affirmatively says otherwise. If there's a no trespassing sign, obviously no presumption of permission. If there's somebody out there telling you to get off, obviously no presumption of permission. But if there's silence, the law presumes you're allowed to go there. So I'm going to skip over this a little bit, but what happens if you don't apply the presumption of permission? And the Supreme Court in Goose Rocks said that this is what happened in the lower court decision. The Superior Court didn't apply the presumption. This is what happened in California. In California in 1970, there was a case like Goose Rocks Beach case over just the high dry sand, and the court said, we're not going to apply the presumption of permission to beach property. And a year later, the California legislature enacted a law to reverse that court decision and said, no, you've got to apply a presumption of permission. And why did that happen? Because this is what happened. A few years later, there was a court case in California that summed up what practically happened in California as a reaction to this change in the law. The court case is called Guy on Beats. And the court said, and this is a direct quote from the California court, reaction to Guy on Beach was prompt. In addition to soaring sales of chain link fences, as owners of shoreline property frantically attempted to bar the public from the use of the property, the case generated a spate of law review comment which was generally critical. So it's sort of like the classic case of unintended consequences. You try to open up this one little beach, but you have the effect of scaring everybody else that owns property away, and they close access. And so I'm going to skip ahead a little bit to, I could talk about prescriptive easements more, and I'm happy to do that, and I'll leave that for questions if people do have questions, but I want to get right down to the happy ending, which is, isn't there a way to avoid the costly lawsuits like Goose Rocks Beach, which was initiated in 2009, still going on, it's costing millions of dollars for the parties, and I think the saddest part about it is simply what's happened to the community at Goose Rocks. You have people that have known each other for 60 or 70 years who no longer speak to each other over this case. I think anyone down there will say it's been extraordinarily divisive. So there is an alternative option. And I think the Goose Rocks Beach case, if anything, really highlighted the stakes that are involved when you go to court and you fight about this in open court. That's where I've done I did a bit of research when I was in law school on this issue, and this is the issue I wrote a law review article about while I was still in law school. So why negotiate for access? These are the easy ones. Takes less time, costs less money, builds the community instead of dividing it, encourages self-regulation. If even backlot owners, for example, are involved, if the town is involved, the beachfront owners are all involved in coming up with a compromise together and creating rules over how the beach is going to be governed, they take ownership in that agreement. Lessons in psychology have showed when you create agreements this way, people are more likely to self-enforce that agreement. And they're more likely to be happy than if you just imposed a set of regulations on them. Breaks down the barriers between opposing groups and gets to underlying interests. I'm going to be talking a bit more about this at the third one, but this is just a brief overview. And finally, the most important part, I think, is it builds trust, which is critically, I think, in Goose Rocks, lacking. There's very little trust right now between the town and backlot owners and with beachfront owners. When you're forced to meet somebody face to face and work out your differences, you start to build trust. So these are taken from a book called Land in Conflict, which was partially written by one of my professors after I left law school. And I'm going to go over in greater detail some of these elements in my next talk. But I want to give you some success stories. This is Parsons Beach in Kennebunk, and this is a privately owned beach. The public has access to this because of an agreement between private property owners and the public on how it's going to be managed. So it's open to public use even though it's privately owned. And that's worked for a while. Pete says he's seen the agreement. I haven't seen what it looks like. Maine Island Trail Association has been extraordinarily successful in doing this. They operate 350 miles of continuous campsites, a large portion of which is on private property. They have stewards that go out there on every property to take care of the property, to help manage it, and they've been extraordinarily successful. The private landowners basically just give them and say, yeah, go ahead. As long as you manage it and manage the public use, we're okay with allowing the public to go there. This is a picture of Crescent Beach. Many people don't know that a large portion of Crescent Beach exists on private property, and the state enters negotiations and gets an agreement with the private landowners who own a large part of that beach. It's mostly the part of the beach that's toward the bottom of your screen is owned by the Sprague Corporation. And so the landowners and the state have negotiated public access to that area of the beach. I don't think that example was extraordinarily creative. It's basically, give us money and we'll let you use it. I think Maine is ripe for a really, really creative approach to this. And so I'm going to end with providing you all some resources. The top is just a basic website about some of the success stories like in Parsons Beach, and it discusses that a little bit. But the next three are all institutes that specialize in large land use disputes and that specialize in solving land use disputes like the ones at Cedar Beach. And I put a plug for the dispute resolution program that I took classes through Vermont Law School, the Consensus Building Institute for Land Policy. These are where the professionals are. There's a lot of ways. Just negotiating and finding a mediator probably won't cut it. You need to find somebody who's a real professional in this kind of issue, consensus building, and you'll be able to find them at these links. So with that, I am happy to answer any questions that people may have.